Hello everyone. This is a quick video that says, never do this as follows. And lawyers almost never say never, but this is one of those times where I really feel strongly about what I'm about to tell you. And I want to protect you. I want to save you money. And I want to help you avoid unpredictable and unexpected consequences, right? So we hear about those kind of things a lot in politics and government, unexpected or unintended consequences. And here's the rule: don't write your own documents. If you write your own documents, they're probably not going to be correct. They just aren't. We read and write sentences for a living. We read the cases that come down all the time. We litigate cases. We've been doing it for 26 years. We've got a lot of combined years of experience, and we are seeing documents every single day that help guide the advice that we give to every single client. So if it's a land contract, if it's a purchase agreement, if it's an option agreement, if it's a lease, if it's just a letter that you're thinking about writing to the other side to convey your position, have us do it for you because it's going to save you money in the long run and it's going to avoid problems. The, the idea of pulling a document off of Google, off the internet, it just isn't smart. Those documents, I don't know where they come from, but I see things all the time from parties in litigation or things that they've done, and they think, well, it looks legal and it's got a lot of legalese and a lot of verbiage, but that doesn't mean that the words are correct. A number of years ago, we had a litigation for a commercial tenant, and the landlord had used a form that they got off the internet, and it dealt with a really narrow legal concept, and I'm not going to talk about it, what it was, but there was just a single phrase in that document, and you would have never thought that it was important, but that single phrase literally ruined the impact of what we could get for the landlord in that case. And the landlord had no idea. And the landlord was a smart, experienced investor. They had a lot of property and they'd seen a lot of documents, but they wrote something that they pulled off the internet and it just was wrong. And when we had to litigate that, it created nothing but problems for them. And this is true all the time. We see oftentimes attorney fee provisions for one side but not the other. And of course, when you see that, you think, what? Why didn't you put that in for both of you? Or there's no attorney fee provision for the client. And so that creates a problem because without an attorney fee provision in a contract, unlikely that you're going to prevail. So here's the rule: save your money, because once you start litigating, it's already a problem. You're already losing money with the other side because the deal has gone bad and you're not getting the benefit of whatever bargain you had for it. And now you're spending money litigating something, and the litigation is more difficult than it needs to be because the documents are not as clear as we would want them to be. So, helpful hint: it's not me trying to make money for ourselves as a law firm to, overbill people. The overbilling is when you have to litigate it. Then you're going to find out what the real bill is, right? So don't do that. Do yourself a favor. Even if it's an operating agreement on an LLC, right? Don't just cut and paste from an old one. It may not be the same going forward, and there might be a new consideration that we need to implement for that new LLC, even if it's another one just for your company. And that happens all the time. So be careful. We want to protect you. We want to defend your territory. We're going to do it for you, but we got to use that ounce of prevention is worth a pound of cure, just like Grandma said. So it's true. Call us. We'd love to help you. We look forward to helping you. Have a great day. Thanks.